All rise.
Yes, Mr. Morley.
Lord, my ladies, as you know, I appear on behalf of the Commissioner. I can assure the court I will be rather quicker than Mr. Bonner, who has taken you to lots of the key material.
Yes.
And I wanted to highlight at the beginning that this clearly is an important case for the Commissioner, and that was certainly identified in the High Court proceedings when the Commissioner didn't even object to the application for permission, because we recognise that this court's decision is going to have a real impact upon the way that police misconduct proceedings are dealt with by chief officers. And the email that your lordship has referred to this morning very clearly spells that out. This appellant is not the first officer to be subject to a condition like this, and there are many hundreds at the moment within the Metropolitan Police that are subject to these so-called not to contact restrictions imposed within the context of either an ongoing misconduct investigation or misconduct proceedings that are ongoing in the form of almost inevitably a misconduct hearing. It cannot have escaped the court's notice over the previous days and weeks and months the difficulties that the Commissioner is having with officers accused of wrongdoing, and is trying everything to be able to deal with wrongdoing or allegations of wrongdoing in a robust manner, because it is clearly a matter of national concern, and policing in this country, we all are very well aware, depends upon public confidence in policing. And it's the Commissioner's clear aim to not only preserve but to promote and, if necessary, repair public confidence in the police service, and in particular the Metropolitan Police. It's an important part of that to ensure that misconduct proceedings are dealt with robustly. And it's an important part of that process that witnesses due to give evidence against police officers are protected. And securing the integrity of those proceedings will therefore, on many occasions, require a direction to an officer not to contact witnesses. And I suspect for a long time, officers, senior officers, have not thought that there was any difficulty with that at all, because it seems like common sense, something that we're all used to in other jurisdictions. Those accused of wrongdoing or involved in proceedings instructed not to contact witnesses, or certainly advised not to contact witnesses as a matter of common sense. And that's clearly the approach taken by the Commissioner insofar as ongoing proceedings are concerned. And at the heart of this case, to cut right through everything, it's Regulation 6.2. It's the Commissioner's interpretation of that regulation that is critical. It's at the heart of this case, and if you're against me in relation to how that is interpreted and how the Commissioner and the High Court or the Administrative Court interpreted it, then we fail. It's really about Regulation 6.2.
Well, that's what troubles me. Can you answer the question I put to Mr. Bournemouth early in his submissions? What is the source of the power of the chief officer to instruct an officer under disciplinary investigation not to contact witnesses?
We would say that it comes within the Police and Social Responsibility Act, the direction and control issue that you've been taken to by Mr. Bournemouth. We've always taken the view that instructing officers, part of their duties, and ignoring the private life issue for the moment, it's part of their duties not to have any contact with witnesses. That's a direction and control matter for the Commissioner. That's where we say the power comes, and I think Mr. Bournemouth effectively doesn't have any quarrel, to use his words, with the ability and the power of the Commissioner to impose restrictions on duty that might include a restriction not to contact somebody as part of the duties. It's the imposition on the private life that clearly causes the difficulties. Now, I would seek to effectively have my cake and eat it by arguing, as I do and did in the court below, that the Police Reform and Social Responsibility Act and the direction and control matters that deals with would potentially also give power to the Commissioner to impose restrictions upon an officer accused of wrongdoing, facing a disciplinary hearing, that does impact upon his or her private life. So I would say that it would potentially stretch that far if it needed to. So if the court was against me in relation to Regulation 6.2 interpretation, I would argue that there is a potential fallback for the Commissioner in relation to a direction and control responsibility, being responsible for the direction and control of the officers under his command and ensuring good discipline and proper misconduct proceedings.
But surely, assume for the moment that you're right, that the direction and control power includes, is the source of the general power to instruct officers under disciplinary investigation not to contact witnesses, which is, I explored with Mr. Bourne, but very often it will have nothing to do with the officer's private life. Is the analysis then that Regulation 6 may limit that general power? That if the case has nothing to do with the officer's private life, or the restriction not to contact the witness doesn't have any impact on the officer's private life, then Regulation 6 has got nothing to do with it. But if it does, then Mr. Bournemouth says, Regulation 6 creates a limit on the general power, and in order to impose a restriction on contacting a witness where that impinges on the officer's private life, the Commissioner has to show that it falls within the exceptions in Regulation 6.2. It seems to me that Regulation 6 can't be the source of the power. That, you may be right, is the primary statute, but it may define an exception to the source of the power.
That may be an interpretation. I wouldn't quite put it that way, my lord. There is the general direction and control power within the Police and Social Responsibility Act, in short. And the Regulation 6 does apply a slight restriction in as much as it must be concerned with the functions of a constable. But my argument would be that in the context of these proceedings, where we are dealing very much with misconduct proceedings, ongoing proceedings, we are well within the territory of functions of a constable in any event. So there's not really a restriction in this context.
Well, you'll come to whether it does fall within that phrase, but it just seemed to me, and something which puzzled me about the judgment below and the argument below, is that Regulation 6 cannot be the source of the power. Because it first imposes some general statutory restrictions, Schedule 1, 6.1, Schedule 1, fine. It doesn't say anything about conduct of disciplinary cases, it says no other restrictions restricting an officer's private life may be imposed except, and then 3 exceptions, or Mr. Bournemouth says 1 exception with subdivision.
Yes. Well, my Lord, clearly our case is that the reading of that first line is critical. No restriction other than those designed to secure the proper exercise of the functions of a constable. So that's the first type of restriction that can be imposed. Those that are designed to secure the proper exercise of the functions of a constable. That's the first part of 6.2, we say. So there's an ability there to impose a restriction on those terms without any recourse or need to go to the Secretary of State. And that's, we say, a literal and clear reading of 6.2, because the no restrictions and then the restriction described, followed by the word except, really sets out the stall, we say, in relation to that first sentence. You've got one restriction there that can be used without any need to go to the Secretary of State, and then 2 further types of restrictions that follow on, where you do need to go to the Secretary of State. And effectively, there's 2 different types of restrictions, but the first category are those designed solely to secure the proper exercise of the functions of a constable, and that's a matter for the Chief Officer, here the Commissioner, and it doesn't involve the Secretary of State at all. The second type is broken down into 2 sections, 2 parts. The first of those second restrictions are those that are not designed to secure the proper functions of a constable, but may still be temporarily imposed, subject to being reported to the Secretary of State. And
can you give an example of one of those?
It's very difficult to know. Our research hasn't found anything that's ever been done along those lines. The only thing that sprung to mind, and I know I'm criticised by Mr. Bournemouth for this, and that was the public order scenario, where I was really, it was just my thinking rather than any evidence-based process. It was really where there was a position of a real national difficulty, and for example, widespread public disorder, or even worse, where officers were being effectively told that they must not go home, they must live in barracks somewhere, they're going to spend 3 months of the rest of their lives incarcerated effectively in a particular geographical location because they are needed to be somewhere full-time because of a dire emergency. So I'm really thinking of it being quite an exceptional situation, and we're not aware of it ever being done. But it is difficult to think of a particularly sound and solid argument. I can only think that it's there just in case of those sorts of dire emergencies. My Lord, the second of the second type, if you like, where the Secretary of State needs to be involved, again, are where there is a restriction that's, again, not designed to secure the proper exercise of the functions of a constable, but they are being imposed following consultation. So we've got a first type, no involvement of Secretary of State at all. Second type, either needs to be referred to the Secretary of State or Secretary of State needs to be consulted. And that appears to us certainly to be the clear, literal interpretation of Regulation 6, 3 types of restriction. And I acknowledge, my Lord, that it starts with effectively a negative, no restrictions other than, but that doesn't, in my respectful submission, mean that restrictions can't be imposed. There is a power there under 6.2, we would argue, to impose those restrictions.
Right, thank you very much.
Well, my Lord, I wanted to just say a brief word about the facts before I carry on. Only to confirm one thing. As Mr. Bournemouth has indicated, the case involving this appellant has moved on, and he is now due to attend the misconduct hearing. And I just wanted the court to be clear about what that means, and the officer will be expected to attend a misconduct hearing in front of a panel of 3 people, one of whom is the legally qualified chair. And to keep it very simple, it effectively amounts to a magistrate's court trial where evidence will be heard, witnesses will be called, and evidence given against the officer. And the potential outcome, depending, of course, upon the decisions of the panel, is dismissal. So for any serving police officer, knowing that you are going to a misconduct hearing, it's a very important and indeed sometimes overwhelming part of their career, knowing however long they've been a police officer that they could be dismissed. And here, in this case, the one witness giving evidence against the appellant is his wife. And I don't need to tell this court about the difficulties that there are in other jurisdictions of obtaining oral evidence from partners of either sex called to give evidence against another partner in relation to their domestic environment and what has happened. And the real concern with a case like this, just talking generically and not about this appellant, is that any contact could lead to a witness changing their mind. This doesn't necessarily mean contact of a malign intent, seeking to persuade somebody not to do something, but that result may be achieved by perfectly proper and friendly contact. Effectively, if you like, mending bridges and the age-old example of getting back together. And that's something that the Commissioner is very mindful of in relation to cases like this, violence against women, domestic violence cases, where we are wholly dependent upon that person coming to give evidence at the misconduct hearing. Because if they do not attend, or if they attend and refuse to give their evidence, that's the end of it. The case, unless there's other witness evidence, of course, that will be the end of the process. So the simple thing to say about the facts is that at the moment is what is happening. We are moving towards effectively a mini trial at which that lady is being asked to give evidence, and she's cooperative at the moment to give evidence against the appellant. So Regulation 6, my lord, we have the interpretation that I've explained, those three types of restriction, and I've added to the bundle what the equivalent is in Scotland. And we've got that in the supplementary bundle at page 255. It's the last page. It's something that wasn't before the court below. It's again something that's the result of further research. And the Scottish police, the Scottish legislature, have something very similar to our Regulation 6. You can see on, we're looking at the Police Service of Scotland Regulations 2013, happens to be Regulation 4, same title, restrictions on private life. Schedule 1 is referred to, we don't have it here, but it's very similar to the version in England and Wales. And this is clearly based upon our Regulation 6. And the version in Scotland starts the same, no other restrictions except those designed to secure the proper and so on. But there's no reference to the Secretary of State. And taking out the Secretary of State takes out my second category of restrictions. And in my respectful submission, this clearly is our interpretation of the first part of our 6.2. That ability of a chief constable or a chief officer to impose restrictions designed to secure the proper exercise of the functions of a constable. That's been distilled in Scotland to a slightly better sentence, but a sentence that is fully in accordance with our interpretation of 6.2. And we say this is helpful. It suggests that our interpretation is correct. It is, of course, in a different jurisdiction, but it's, by analogy, we say a suggestion clearly that we are right, that restrictions can be imposed by a chief officer if they are designed to secure the proper exercise of the functions of a constable. And Lord, I'd ask your Lordship and ladies to consider the appellant's interpretation of 6.2, because it seems to us that the appellant is really reading in words to 6.2 and appears to be suggesting that it should really say only restrictions designed to secure the proper exercise of the functions of a constable shall be imposed, and when they are, and even if they are, the Secretary of State must either be notified if it's a temporary measure or consulted if it's not. And that appears to be what Mr. Bourne was encouraging the court to find, that on any restriction being made under 6.2, the Secretary of State must be involved. And we simply say that's not right. That is just not a coherent interpretation of 6.2. Now, my Lord, I know it's not as simple as that, but essentially, I would argue that if you are in agreement with the Commissioner's position insofar as the interpretation of 6.2 is concerned, then ground one on this appeal effectively fails. Because you would find that Mr. Bourne's interpretation is incorrect, and that the interpretation argued in the court below and found by Mrs. Justice Lang in the court below is correct. So it is very much a case of statutory interpretation, and I know that Mr. Bourne has made several points about why that can't be the case, looking at other matters in his skeleton argument, and I've dealt with that in my response. I simply say they don't amount to very much, and they certainly do not dislodge the primary submission that reading this logically and literally, this can only mean one thing, that there are three types of restriction. It can't mean what Mr. Bourne contests or argues for. I acknowledge, of course, that there is a separate argument in relation to what the proper exercise of the functions of a constable actually means. And I have to address that, because if you're against me on that, then I concede I've got difficulties in any event. I dealt with this briefly in my skeleton argument, paragraph 52, in the core bundle at page 48. And it's really, my paragraph 52 really builds upon and adopts what was said in the administrative court below, at paragraph 75, which I'll come to in a moment. And the functions of a constable go further than the obvious. And the argument that we deployed, and I seek to deploy again, is that given the need to maintain public confidence in the police service, part of the functions of a constable are to do the same. Maintaining public confidence in the police service is not solely the role of the commissioner or senior officers. It is the role and responsibility and function of every constable. And part of maintaining public confidence in the police service means the integrity and the robust nature of the misconduct system, investigation of complaints, misconduct proceedings, and they must all, of course, take their proper course in order for public confidence to be maintained. Now, this is Justice Lang dealt with it at paragraph 75 of her judgment. My Lord, page number for that is 79 in the core bundle. Page 79, core bundle, paragraph 75. I'll be brief because Mr. Bourne has already drawn it to your attention.
Yes.
Effectively, the latter half of paragraph 75, starting in the middle with, in my view, compliance with these standards, and so on. Here we have an officer subject to disciplinary proceedings. Those proceedings would clearly be jeopardised if a key witness was interfered with. And it's our position that preventing an officer under investigation, waiting to go now to a misconduct hearing, from having any contact with a witness, in this case the main witness in the case against him, is part and parcel of securing exercise of the functions of a constable. For the reasons I've just explained, because police misconduct, how it's dealt with, public confidence in the integrity of the police misconduct system, the disciplinary process and hearings is so critical. It is part of every officer's function to make sure that that is not put in jeopardy, that function, the misconduct process. Mr. Bourne has drawn your attention to the case of Ahmed. I rely upon that as well. My take is different. My Lord, it's Authorities Bundle, page 193. And again, I'll be brief because Mr. Bourne has drawn your attention to this. Bottom of page 193, paragraph 25(4). And it's the last 2 or 3 lines that I place reliance upon. So effectively, it's the last word on page 193 in the context of the functions of a constable. Last word, to, over the page, to protect, help and reassure the community, and to be seen to do all of this with integrity, common sense and sound judgment. And we say that encompasses the police conduct regulations, the complaints, disciplinary process. It's all part of the function of being a police officer. And I make 3 particular, similar but slightly discrete points about this. The first is to repeat that this is about public confidence, but the Home Office guidance and the general approach to police disciplinary proceedings is that the main purpose of those proceedings is to maintain public confidence in the police service. It's dealt with in the Home Office guidance, which effectively says there are 3 reasons, 3 overarching purposes for the misconduct regime, and the first is maintaining public confidence. The second is to uphold high standards, and the third is to protect the public. The simple point is that public confidence is so critical, it's a key purpose of the misconduct regime, and the function of a constable is to maintain public confidence. So it's part of the functions of a constable to make sure, ensure that proceedings taken against them are dealt with perfectly, properly and robustly. And that's different to being impartial. I take Mr. Bourne's point, he's of course absolutely right. You can't be impartial in your own case, and it would be quite wrong to suggest otherwise. But there's a difference between being impartial and doing something that you're not supposed to do. And it's not good enough, we say, to simply say, well, officers are bound by the code of conduct or the standards of professional behaviour, and they're obliged anyway to act with integrity because that's what the standards are. When you've got an officer accused of wrongdoing, and recognising, of course, that they're innocent unless anyone decides otherwise, but recognising that's the territory, we're here because an allegation, a serious allegation has been made against this officer. It's just not good enough to say, well, you're bound by the standards, don't do anything wrong. It must be proper to tell, instruct, direct an officer that they must not contact a witness. And that's not about being impartial. It's about abiding by process. The second connected point is it's not just about public confidence in that individual process, that individual misconduct hearing. It's public confidence in the wider processes, the wider scheme. Public confidence in a particular hearing, public confidence in the wider scheme of misconduct hearings. And police officers have I would argue, a function to promote public confidence under both of those headings. There's a risk, clearly, that an officer who has done wrong and is looking at a misconduct hearing, there's a risk that they won't abide by the standards expected of them. And the only way that the Commissioner can address that is to really make some sort of preventative direction, as was done here, which is you're not to have any contact with the witness. Because otherwise the process will be frustrated. And the third point is, building on that really, as to why, and I've flagged this up already, as to why it's necessary to have a restriction and not simply leave it to the standards and an officer breaching the standards. Because an officer won't necessarily breach the standards if they have a pleasant conversation with a witness. That doesn't necessarily breach the standards if there's some innocent contact. There's no dishonesty, no lack of integrity, talking to somebody about children, excuse me, or something else. But in a case like this, where we're looking at domestic abuse, serious domestic violence, innocent contact, friendly contact, that doesn't breach the standards, that wouldn't amount separately to any separate allegation, could still defeat the process. So irrespective of malign intent, there's a real need from the Commissioner's perspective to impose conditions on an officer accused of wrongdoing when it comes to witnesses. Now, Commander Betts, who dealt with this in the first instance, my lord, my ladies, it's at page 147 of the core bundle. It's a document I think we've looked at. Core bundle 147. We didn't look at the part that I want to look at. This is described as the NPCC officer's decision. National Police Chiefs Council senior officer, in this case Commander Betts. And it's in the centre of the large box, paragraph beginning, "I have reviewed." And the commander's setting out why he's imposing these conditions, the third of which is the not to contact condition. "I've reviewed the circumstances of the allegations against the officer. In my assessment of the risks, the officer has demonstrated alleged criminal and unprofessional behaviour." That's a separate matter for him. "I'm of the opinion that these risks require management to ensure public and stakeholder confidence and organisational confidence of officers and staff within the NPS. I consider placing the officer on restricted duties ensures appropriate management of these risks." Now, the other risk identified there by the commander, as I understand it, is the confidence not of just of the public that I've spoken about, but the confidence of the rest of the organisation. As you're well aware, Metropolitan Police, huge organisation, I think 40,000 officers, huge amount, as well as staff. And they need to have confidence in the organisation. They need to have confidence in the senior officers and how these misconduct proceedings are being managed. I don't place as much weight on that as I do public confidence, but it's clearly something that was in the mind of Commander Betts when he made the initial decision. I respond as well to Mr. Baumber's assertion that, well, all this is well and good, but an officer could just resign anyway. And then we're out with the functions of a constable. And I take issue with it being that simplistic, because yes, we can't stop an officer resigning. An officer that's going to a misconduct hearing can at any time resign. And yes, the proceedings can still proceed, notwithstanding that an officer has resigned, and the process will carry on with or without the officer. But there's...
Whose decision is that?
I think it would initially be the appropriate authority's decision, my lord. So that effectively the Commissioner's decision as to whether to proceed or not, and the clear guidance from the Home Office is that unless there's good reason not to, for example, illness, then you would generally proceed.
Yes.
But the issue changes from the Commissioner's perspective, because if you've got somebody who's no longer an officer, then they're less likely to damage public confidence if they do something. and clearly the restriction wouldn't apply in any event because they're no longer a serving police officer. But if they did go and contact a witness, then they're not a serving police officer. So it would clearly have an impact on the process, it would clearly have an impact on the witness, but it wouldn't have the same effect upon public confidence, because any ex-officer doing the interfering or doing something inappropriate is no longer an officer. So still a problem, but not to the same degree so far as public confidence is concerned. And to keep it short, my Lord, we agree with the judgment below. Core bundle 79, so current bundle that we're in, please, page 79, and I'm sure it's a paragraph, yes, back to paragraph 75. And the conclusion there, that the appellant exercising his functions properly within the disciplinary proceedings, not jeopardising them by interfering with the complainant, is the key issue. It's being bound, it's the functions of a constable to cooperate and promote public confidence, and I would respectfully invite your Lordship and your ladies to agree and find that the summary in paragraph 75 in the court below is correct. And if you're with the Commissioner in relation to the arguments on 6.2 and functions of a constable, then the appeal should fail, subject to Article 8, which I'll come to. So, Lord, those are my submissions on Regulation 6. And I'll turn to say a few more words about the Police Reform and Social Responsibility Act, if I may. Dealt with that to a degree already. I accept that this is broadly drafted as a high-level general power on commissioners or chief constables to secure an efficient and effective police service, direction and control of the police service. But direction and control, albeit high level, clearly relates to situations like this, because it's the Commissioner that's made the decision to apply restrictions to certain cases. That's effectively the direction and control high-level decision. In this organisation, we will look to impose restrictions on officers accused of wrongdoing, and the lower level decision-making, the more granular decision-making made by perhaps commanders here on individual cases, is something slightly different. So we've got the direction and control decision-making by the Commissioner. We're going to do this. And then we've got the individual granular decisions made by, still senior, but less senior than the Commissioner, making decisions on individual cases. There's a policy decision, if you like, if I'm not using the wrong word there, internally for the Metropolitan Police. But it's all about maintaining an efficient and effective police force service. And that's set out in the policing protocol that your Lordship's attention has been taken to. And just to flag up without going to them, the key paragraphs in the protocol are 21 and 22. I'm sure Mr. Bournemouth took you to them about direction and control, about efficient and effective policing. And I say again that the judge below got this right.
Could I just have the page reference to those particular paragraphs, please?
Forgive me, my lady. Yes, it is 195 in the supplementary bundle, moving on to 200 in the supplementary bundle. I'll just turn them up myself, double check the references. 195 is the start of the Act, and then 200 is the content of the protocol, and it's page 200 where, I know Mr. Bournemouth took you to this, paragraphs 21 and 22, talking about direction and control, and in 22, efficient and effective policing. That's it. Right. yes, and I'm reminded that Mr. Bourne also took you to paragraph 33 at 202 about direction and control. So
This statutory instrument draws a distinction between let's call them policy and strategic decisions and decisions in individual cases. And it does so, I suppose, because PCCs, putting it very broadly, are allowed to interfere or have some input into the strategic decisions, but not into the decision as to whether, in an ordinary criminal case, to prosecute, to arrest and charge an individual suspect. And I suppose PCC has no input into decision whether to suspend an individual officer, bring disciplinary proceedings against an individual officer, impose restrictions on contact with witnesses. But then can it be right that the 2011 Act, Section 4.3 for the Commissioner, Section 2.3 for any other chief officer, is the source of the power in this case?
Well, I think I've argued that yes, it can, yeah. Because it gives the Commissioner power to direct and control his officers, and we would argue that that does give him effectively the initial overarching power to say we will impose conditions in these sorts of cases as a policy overarching decision and a power to do so, and then for less senior but still senior officers to make decisions based upon that direction in relation to cases like this.
But it isn't it Commander Betts?
Yes.
Isn't he in law the commissioner for these purposes? In the decision, all the decisions relating to BC Philpot, indeed, are surely made in the name of the commissioner.
Oh, that must be right. That's right. You know. But the commissioner wears many hats.
Yes.
And for example, in the misconduct process, the commissioner is technically the appropriate authority that makes decisions. Yeah. Other people make it on a delegated basis, but it's all, you're quite right, my lord, in the name of the commissioner. But I would argue that that doesn't interfere or water down my argument that effectively, yes, it may be the commissioner making both decisions effectively, because although I've sought to mention the individual senior officer, it's effectively the commissioner first of all making a direction and control decision. This is what we are going to do. My decision is we are going to be imposing conditions in these sorts of cases where it's appropriate to do so. Yes, made by the commissioner. In individual cases that may be made by a commander, but yes, you're absolutely right, in the name of the commissioner. But they are qualitatively different, because one is direction and control overarching, and one is within the compass of that decision made earlier by the commissioner. So I would say that if you accept that argument, really the North Yorkshire case is distinguished, because the North Yorkshire case was about whether a complaint could be made about a chief constable having made a decision in relation to an investigation. And it was determined that that falls within the direction and control description, so therefore no complaint could then effectively be made or recorded against the, in that case, chief constable. And that's just different to what we're looking at here, where we've got a commissioner potentially wearing two hats. One's the direction and control decision, and one is making the more granular decision in relation to individual details. So the description relied upon in the North Yorkshire case about direction and control, it's being used today by Mr. Bourne, but not in relation to the Commissioner's overarching direction and control decision, but in relation to the more granular decision made by Commander Betts, albeit in the name of the Commissioner. So I would simply say North Yorkshire is just very different from what we're looking at here, where we have two senior officers, the Commissioner and the Commander, potentially making decisions at a high level and a lower level. It's just different from North Yorkshire. But I fully recognise that there is some force in the arguments about what is direction and control, and the appellant and the respondent differ in our interpretation of what that means. But we maintain our position that the decisions made in this case, insofar as the imposition of restrictions, do fall within the direction and control responsibilities of the Commissioner.
Mr. Bourne took us to Judge Langan's decision in the North Yorkshire case and said that the Federation would like us to say whether paragraph 39 is right or wrong. I'm not promising that we will, but since we've been asked to say something about it, I'd be grateful for your submissions.
I think I would accept that direction and control decisions are of a more general nature. And in this case, my position is that the decision by the Commissioner to use restrictions in police disciplinary cases is a general decision. It's of a general nature that fits and falls within the definition of direction and control. If individual decisions are being made on individual cases, that's probably not within direction and control. But in this case, I'm seeking to argue that the decisions of both the Commissioner in the first instance and the Commander in the second instance in the guise of the Commissioner fall within direction and control, because it's part of an overarching direction and control decision. It follows on, if you like, from the higher scale general determination. Well, I think that's...
Well then, what do you say about Judge Langan's sentence, quote, "A decision by a chief officer which is confined to a particular subject falls outside the scope of direction and control."
Yes, in the context of the North Yorkshire case, my lord, I would accept that a complainant who was unhappy with decisions in this case would not be able to complain and have it recorded insofar as the Commissioner's decision to impose restrictions generally, because that's of a general nature, it would fall out with the ability to complain, as in the North Yorkshire case. But if a complainant wanted to complain about Commander Betts's decision to impose restrictions in any particular case, that, within the North Yorkshire scope of who can complain against whom, would not be a direction and control matter and could be complained against. But how direction and control is identified and defined within the concept of who you can complain against is rather different to the context that we're talking about. So, yes, I can see that in the North Yorkshire case, if this was the position here where an application had been made to complain against the Commissioner and or Commander Betts about their argument, about their decisions, there would be tremendous difficulty. There would be no complaint that could be made against the Commissioner for making the overarching decision, according to the North Yorkshire. But there would be an ability to complain against Commander Betts because of his decision, albeit in the name of the Commissioner, but his decision would fall out with direction and control. But that's in the context of complaints and the ability to make complaints and the definition and the wording of the, I don't want to get the wrong statute, paragraph 5 of the Police Reform Act that Mr. Warmer took your Lordship's attention to at paragraph 17 of that judgment. So the context is different.
Thank you.
My Lord, I think I can next perhaps turn to Article 8. And yes. I can make a number of concessions because Mr. Bourne's right about lots of the law in relation to Article 8, and there's no real argument between us about the Metropolitan Police Service and the Commissioner being bound by the Human Rights Act. There's no argument about the case of Ruckin and Cleveland Police Authority about right to private life on duty. All of that is accepted by the Commissioner. And if you are against me in relation to the arguments on Regulation 6 and so on, obviously this falls away anyway. Yes. But if you're with the Commissioner in relation to the other arguments, then so far as the arguments put forward on behalf of the appellant in relation to the Human Rights Act, I would simply argue that the decision in this case was necessary and proportionate. And there are really three key elements why we say the restrictions would be, in the first instance, necessary. And we argue slightly wider than a learned judge in the administrative court. We would say it's public safety, prevention of crime and disorder, and the protection of rights and freedoms of others. There's potentially three areas that are relevant. So far as public safety is concerned, and I don't want to repeat old ground, but public safety really is an argument again about public confidence, because the public depend upon the police to protect them. And if they lose confidence in the police service, if they lose confidence in the way that the police service deals with complaints, allegations of wrongdoing, violence against women, then that's going to damage the public-police relationship. Confidence will deteriorate, public safety will be at risk. It's as simple as that. Because if the public do not have confidence in the police tasked with protecting them, there's a real risk of public safety being jeopardised. And a similar point in relation to prevention of disorder and crime. So I'm thinking public safety really along the lines of crime, prevention of crime. It's not about this officer committing a crime. It's about the impact upon crime and disorder if the public lose confidence in the police service and the ability of the police service to prevent crime and disorder. And it's a real risk. If the public lose confidence in police officers, then there's a real risk of crime and disorder breaking down, good order breaking down. And to a lesser extent, the protection of the rights and freedoms of others here, we're clearly focusing upon the ex-wife, ex-partner, but generally speaking, we're talking about witnesses, the rights of witnesses, complainants, people that have made a complaint about the actions of a police officer. We would say that those three elements would mean that interference with Article 8 rights would be necessary, because policing is so dependent upon public attitudes in this country. And proportionality is clearly important as well, and I readily acknowledge the arguments made about other types of cases where other relatives may disagree with restrictions being made. But that's not what we're dealing with here. We're dealing here with a lady who wants this, wants the restriction to remain in place, doesn't want any contact with the husband. And it's in place to protect the public, maintain professional standards and promote the disciplinary process. And it's absolutely right that the appellant's wife could have got a non-molestation order. Of course she could. She could go and get one. The arguments from our perspective, however, are different, because our concern, of course our concern is about protecting her, but that's not what this is about. Our concern is about protecting the integrity of the police system, and that's not her responsibility. She can go and get a non-molestation order to protect herself. That's not going to assist us, really, and it shouldn't be down to her. If the Commissioner or a senior officer wants to take steps to protect the integrity of the police misconduct process, then it's the Commissioner that should do it, and the Commissioner can't apply for a non-molestation order. And yes, it's preventative so far as harm is concerned, but again, without repeating myself, if there's no malign intent, if there is accidental contact that then develops into more innocent contact that might not technically breach the non-molestation order, depending on how it's drafted, there's still that continuing risk. And it's the Commissioner's responsibility. It's not the witness's responsibility, it's our responsibility to take steps. And that's what we've tried to do. And if we're wrong, we're wrong. But I hope we're not, because it's very important to the system to prevent contact with witnesses. And Mrs. Justice Lang really summarised this at paragraph 94 onwards in her judgment. Well, that's in the core bundle, page 82.
Yes.
Again, I'm sure we've looked at this. Talking about proportionality, non-molestation orders, I take your Lordship's point about non-molestation orders being preventative, but that just doesn't deal with the concern of the Commissioner in relation to that as being a potential avenue. And the interference in this case is proportionate. Forgive me for a moment while I just check a reference I've got here. The last thing to mention in relation to something that Mr. Bournemouth said, so far as Article 8 is concerned, is the lack of a proper process. And I can't get around that because there isn't a clear process for an officer to challenge a decision made to restrict them. There isn't in the regulations anywhere a process that needs to be followed. However, I would argue that there is an internal process that would protect an officer, and that's really by way of internal reviews. And there's an example of that in, I think we're back at Commander Betts's initial decision. Yes. So, my Lord, it's at page 147 in the core bundle. I drew your Lordship's attention to Mr. Betts's explanation and concern about risks in the middle of 147. But over the page at 148, there's third paragraph up. And I appreciate this is an internal process, but it's an internal process that forms the basis of this pro forma document, and it spells out very clearly that the circumstances of officers placed on such restricted duties will be reviewed. First of all, should there be a significant change in circumstances? So just pausing there. If in this case, for example, the witness said, well, I do want to see him, thank you very much, he's my husband, I want to see him. Or a child, in a different example, that would lead to an internal review. And following on in that same sentence, or where a request is made by the officer concerned or their representatives. So there is a process for a review upon a change of circumstances and a review following representations from an officer. Now, that's not spelt out. I'm not aware of a particular policy or process any further than what we have in the bundle before your Lordship. But there is clear recognition that if a decision is being made, and in this case a decision that has an impact upon an officer's Article 8 rights, there is a process by which that can be reviewed. So the fears and concerns raised by Mr. Bournemouth, and he half highlighted this when he was making his representation, are dealt with and recognised by the Commissioner. And there's not a need for a formal process in every case. What is necessary is the ability to review, reconsider, and representations to be made by the person affected. And that's what's happened or would happen here. The last thing to mention on Article 8, and harking back as well to a word used in the Regulation 6.2 part of this case, and it's not a word that really we focused on because it's not been important, it's not of importance really, but it's interesting that the words used by Parliament in Regulation 6.2 talk about imposing a restriction. And that's significant in my respectful submission because we're not dealing with members of the public, we're dealing with a disciplined, hierarchical organisation where officers give orders to junior officers. And of course Article 8 is important, but you've got decisions being made by senior officers. They must be necessary, they must be proportionate, of course. But once a decision has been made, it's imposed upon the officer in a disciplined organisation. And within that disciplined organisation, there is a right to have that reviewed. And if an officer within a disciplined organisation is unhappy with any decision, there are processes for review by more senior officers. So the interference here, I argue, and effectively rely again upon Mrs. Justice Lang's description in her judgment at paragraph 99, called on page 83, where she summarised the proportionality issue and concluded that despite the fact that there was an issue so far as the incorrect process being used by the Commission in the first instance, that the outcome would have been the same. This is a different point. I don't think there's a challenge to the... Is there a challenge to 99? If there's a challenge or not, we say that the judge at 99 got it right in relation to that final determination. So, my lord, my ladies, in a very short summary, our position is that the Commissioner does have a power to impose restrictions under Regulation 6.2 and or the Police Reform and Social Responsibility Act. The restriction in this case was properly imposed. It is an interference with the officer's Article 8 rights, but it is necessary and proportionate. And the infringement upon his effective right to a private life is reasonable, given the circumstances of an officer in a disciplined organisation facing serious allegations that potentially have an impact upon public confidence. My lord, my ladies, unless I can assist any further, those are my submissions.
Thank you very much, Mr. Morley. Mr. Bournemouth.
My lord, my ladies, may I just reply in brief fashion on 5 points?
Yes.
The first is the public order example that my learned friend gave for temporary restrictions that are for purposes otherwise than securing police functions. Effectively, my learned friend was saying that at a time of national emergency, officers may need to be deployed in a certain area or from a certain barracks. In my submission, that really is talking about cancelling leave and a deployment decision in a certain location. There would be no problem with that, a deployment decision not being a restriction on private life. If that decision went further to say, then you must never go home during your off-duty time, or you must not move your family nearby to the barracks when you're policing in that area, or don't step foot outside the barracks during off-duty time, then it would be objectionable. But the example my learned friend gave in my submission wouldn't be a restriction on private life. And if it were, it begs the further question of how is that example not securing the proper exercise of the functions of a constable? The respondent's submission seems to be that a decision to deploy officers in a certain location to respond to a public order event, it cannot be described, is not described as securing the proper exercise of the functions of a constable, because that was the task that was placed before the respondent to explain what temporary restriction might be necessary. It is not concerned with the functions of a constable, it appears in my submission that the example given relates very directly to functions, but would not be a private life restriction in any event. The second issue is that my learned friend said that the authority are dependent on the witness. In respect of discipline cases, the chair of a discipline hearing has the power to issue witness summons under the Local Government Act of 1972. By the time a decision is made that a person is a witness, the authority plainly would have a witness statement from them, and in any event, hearsay is admissible in discipline proceedings. It may be if it was the sole and decisive evidence, and it was unfair to adduce such evidence, that the chair might in their discretion exclude it for unfairness.
It also affects the weight to be given to the evidence.
And to the weight to be given to it, albeit if it is unfair, then the chair might exclude it altogether. But the dependence on the witness is subject to those rules, there being no strict rules of evidence or procedure in police discipline cases, those being matters for the chair.
I ought to know this, but I don't. The chair of a panel can issue a witness summons, but what sanctions, if any, are there if the witness doesn't turn up? And she couldn't be arrested, could she? It's not like a criminal court.
I think Mr. Morley may know. Mr. Morley presents rather than.
It's issued by the county courts.
Yeah. The provisions through the Local Government Act. I'm grateful to Mr. Morley, who sometimes has to apply for such things. Are issued through the courts, and so it would be a contempt because you'd be breaching the direction of the court. Really. The Scottish regulations, I say two things. The first, that these are not the regulations that we are considering. They are similar. They're similar in ways. Schedule 1, which we don't have, of the Scottish regulations, I think includes some of those general restrictions: politics, the lodges, paying debts, but not all of them. The prescribed organisations are not there. But my second point is that it's unsurprising that in the exercise of devolved powers, that Scottish legislators would not wish to subject Police Scotland to the total control of the Secretary of State sitting at Westminster regards decisions on the conditions of their police officers. So what appears to have happened is that the Scottish provision has removed the part which provides for Secretary of State superintendence over all conditions, which is the submission that I made as to the meaning of Regulation 6.2, and as such it supports the submission that we had made, that approval of the Secretary of State is needed for all such restrictions in England and Wales. What's happened is that that Secretary of State at Westminster provision has been removed for the Scots. Fourth of 5, my learned friend gave a number of reasons why the respondent would like to have such a power, or why there might be arguably a need or an attractiveness for the power that they contend for in this case, citing, for example, the importance of the discipline aims, national concern over police conduct, or the unintended effect of innocent contact between an officer and a witness, or of reconciliation and its impact on the case. In my submission, that does not aid the argument for the existence of a power. The respondent in my submission has left the forensic points that are made on behalf of the appellant as to why there is no such power largely unanswered, and also those anomalies that we sought to describe to the court that arise on the respondent's construction of the provision in my submission have not had an answer. I concede that the importance of the matters that my learned friend has spoken about regards police misconduct, national concern, the seriousness of any allegations, would be relevant to the balancing exercise under Article 8 if one were to get there. But in order to reach the balancing exercise under Article 8, the interference first has to be in accordance with law, and that is the point at which the parties concentrate their submissions and are furthest apart. And so the reasons why the power would be, that the Commissioner would be grateful for such a power in my submission, goes nowhere to establish that it exists. Finally, it was submitted as I understood it on section 4.3 of the PR SRA that it was demonstrated that this was a high-level decision within the meaning of set direction and control because it was made by the Commissioner. There are two problems with that in my submission. The first is that by that rationale, every decision made by the Commissioner would be direction and control, which we know from the North Yorkshire police case cannot be right. And the second is that the Commissioner herself, as it was, himself now, is not making these decisions. They are, of course, being made under delegated powers. My learned friend, in his submissions on section 4.3, conceded that an individual case decision would not be direction and control. In my submission, this plainly is an individual case decision. My Lord and my Ladies, those are my observations in reply.
Thank you very much, Mr. Warmber. We're grateful to you both. We will reserve judgment and, in due course, send out a draft. Two things to say about that. First of all, as counsel, experienced counsel very well know, draft is sent out for correction of typographical and obvious factual errors, not for re-argument of the case. And secondly, it's subject to the embargo on dissemination referred to in the Counsel General for Wales case. I think it's right to say, not just from Mr. Bulmer, but on behalf of the court, that in a week in which there has been the most terrible, high-profile case of a Metropolitan police officer pleaded guilty to a number of very grave offences. This is a case in which Mr. Philpot has not only not been convicted of any offence, but the prosecution against him has not been proceeded with, and we are now in a position where there is a pending disciplinary hearing in which, as Mr. Morley rightly accepted, he remains innocent until and unless findings are made against him. It's only right to say that. Thank you all very much.